Good afternoon, sir. Could you please state your name and provide your date of birth?
John Charlie Moreno Aguilar, 12.
Mr. Aguilar. Sir, you are here on 2 Superior Court probation violation warrants for alleged violations of terms 3 and 5. I've appointed you an attorney. You have a probation hearing July 26th, 8:30 a.m. at the downtown Phoenix Superior Courthouse. And one of these warrants, Mr. Aguilar, you are non-bondable. The other is a $900 bond, but don't pay that bond because even if you pay it, you'd be non-bondable in the other case. So you will remain in custody until July 26th. Then you'll see the probation judge who will determine whether to reinstate your probation. Mr. Aguilar, do you have any questions? All right. Thank you, sir. Brad McDonald and then Richard Archuleta will be on deck. Good afternoon, sir. Could you please state your name and provide your date of birth?
Brad McDonald.
Thank you, Mr. McDonald. Mr. McDonald, you're here on a Superior Court new case. I find probable cause for the allegation of 1 count of aggravated assault with a deadly weapon or dangerous instrument, which is a Class 3 felony, 1 count of assault, a Class 1 misdemeanor. I've appointed you an attorney. You have a status conference on July 25th, 8:31 a.m., and a preliminary hearing July 29th, 8:31 a.m. at the downtown Phoenix Superior Courthouse. Mr. McDonald, I am setting bond in the amount of, just a moment. I do need to edit this. I'm setting a $25,000 security appearance bond. The county attorney's office did request a $50,000 bond. However, I find a $25,000 bond is appropriate in this case. So that it's a secured appearance bond. What that means is you can pay that directly or work with a bail bonding company. They generally require 10% plus collateral, which would be $2,500. If you pay your bond, you will be released. You're then promising to go to court on all of your court dates. You'll have an ankle monitor installed and must comply with supervision, and you must comply with the standard conditions and restrictions of release. In addition, Mr. McDonald, you're not to return to the scene of the alleged crime. You're not to initiate contact with any alleged victims, complainants, or witnesses, and you're not to have any physical contact with any alleged victims. You're also not to possess any weapons. You must find an alternative residence, provide proof of the same to the court, and you must obey the terms of any order of protection or injunction against harassment that has been issued or which may be issued. You may have no contact with the alleged victim for any reason, even if she contacts you first, and you may not reside at the same location as an alleged victim, even if you are an owner or a renter of the residence. You're entitled to 1 civil standby. That's where you contact local law enforcement and schedule a time to meet an officer who will escort you to the residence so that you can obtain your essential belongings. Please be aware a violation of a no victim contact order may result in the charge of aggravated harassment, which is a Class 6 felony. Mr. McDonald, do you have any questions?
There's no way I can get on that one where you monitor me the whole time. I mean, I've never been in trouble before. I got a job that I never miss. I've been there 25 years. I'm not going to do. I will be there when I'm supposed to be there. I've never been in trouble with the law at all. Just one incident, and I never even got close to her. My daughter was exaggerating when she called.
Yes, Mr. McDonald, the state constitution requires me to set a bond based on a number of factors, one of which is victim safety as well as public safety. And so, sir, I mean, the alleged victim here did have a mark on her face and swelling to her eyelid. There were also the knives involved as well, and so I am going to keep the $25,000 bond in place.
Okay.
All right. Thank you, Mr. McDonald.
Thank you.
Richard Archuleta and then Samuel Malone will be on deck. Good afternoon, sir. Could you please state your name and provide your date of birth?
Yeah, Richard Archuleta.
Thank you, Mr. Archuleta. Sir, you're here on a Superior Court new case. I find probable cause for the allegations of 20 counts of trafficking stolen property in the first degree. It's a Class 2 felony. 1 count of burglary in the second degree, a Class 3 felony. 1 count of possession or use of dangerous drugs, a Class 4 felony. 1 count of possession or use of drug paraphernalia, a Class 6 felony. I've appointed you an attorney. You have a status conference July 25th, 8:31 a.m. Preliminary hearing July 29th, 8:31 a.m. at the downtown Phoenix Superior Courthouse. Mr. Archuleta, I'm setting bond in the amount of $25,000 in your case. It is a secured appearance bond. That means you can pay that amount directly or work with a bail bonding company. They generally require 10% plus collateral, which would be $2,500. If you pay your bond, you'll be released. You're then promising to go to court on all of your court dates, promising to comply with supervision, and you will have an ankle monitor installed, and promising to comply with the standard conditions and restrictions of release. In addition, you're not to return to the scene of the alleged crime. You're not to initiate contact with any alleged victims, complainants, or witnesses, or have any physical contact with any alleged victims. You're not to possess any weapons, and you must submit to DNA testing at the arresting police department. Mr. Archuleta, do you have any questions?
yeah, well, I don't have the money to bail it out. I was just asking, what about a no wire? Is that possible? I mean, it's not, I've always came to court, always showed up on court, whenever my court date was, whenever I had a court date. I'm not a flight risk or anything like that.
Yeah. So, sir, I mean, you know, given the allegations, it's 20 counts, you know, for the trafficking stolen property, class 2 felony, you know, the impact to the victim as well. I am going to keep the bond at $25,000.
Okay. All right, Your Honor.
Thank you, Mr. Archuleta. Samuel Malone and then Javier Valdez will be on deck. Good afternoon, sir. Could you please state your name and provide your date of birth?
I'm Samuel Malone.
Mr. Malone. Mr. Malone, you're here on a Superior Court new case. I find probable cause for the allegation. 1 count of aggravated assault of an officer, a class 5 felony. 1 count of resisting arrest using physical force, a class 6 felony. 1 count of endangerment, a class 6 felony. 1 count of false reporting to law enforcement, a class 1 misdemeanor. And 1 count of carrying a deadly weapon while being under 21 years of age, which is a class 3 misdemeanor. I've appointed you an attorney. You have a status conference July 25th, 8:31 a.m. at the downtown Phoenix Superior Courthouse. You have a preliminary hearing July 29th at 8:31 a.m. Mr. Malone, I am setting bond in the amount of, oh, sorry, Tom, I've got to change this one too. Setting bond in the amount of $25,000. It is a secured appearance bond, so that means you can pay that amount directly or work with a bail bonding company. They generally require 10% plus collateral, which would be $2,500. If you pay the bond, you will be released. You're then promising to go to court on all of your court dates. And you'll have an ankle monitor installed and must comply with supervision. You also must comply with the standard conditions and restrictions of release. Plus, you're not to return to the scene of the alleged crime. You're not to initiate contact with any alleged victims, complainants, or witnesses, or have any physical contact with any alleged victims. You're not to possess any weapons, and you must submit to DNA and fingerprinting at the arresting police department. Mr. Malone, do you have any questions?
It's no way, like, I'm able to get released on pre-trial, nothing, because this is my first time getting in trouble. Like, I'm the one, like, I have a kid, and I'm the primary caretaker. Like, I'm the only one that makes the money, you know. So, like, I just feel like y'all could just understand where I'm coming from, you know. Like, put me on ankle intensive, whatever. I just need to be with my kid and to take care, because there's nobody else that's gonna, like, go to work like I do. None of that, you know. Like, this is my first time doing any of this. The reason why I'm in here, the people never told me that I was banned for life. Otherwise, that's why I came back to the mall. I have too much to lose. I'm not going to go to a mall that I know I'm banned at. And even the police officer told me himself, he never told me how long, you feel me? So I assumed that I was only banned for a year, because that's normal. Nobody ever told me I was banned for life, so I came back. So that's the whole reason why I was even there in the first place. I didn't disobey anybody and come anyway, none of that. Yeah.
So the concern here, Mr. Malone, is the fact that you dropped the weapon and the 2-year-old picked it up.
Oh, I understand that, sir.
So so, Mr. Malone, I would hope as a father, I mean, imagine if your child found a weapon that was armed and loaded.
Yeah.
And I've seen, by the way.
Yeah, I understand.
I've seen cases where kids kill themselves.
I understand that.
And it's horrifying. And so that's the That's the problem, sir. I mean, you shouldn't have been in possession of a firearm to begin with and then put it in a place that a young child picked it up. And so that's the concern I have for public safety.
But, like, I mean, I don't mean to interrupt you, sir, but I was told before I got out of juvie, when I went to juvie, my PO, my probation officer, Nicole Cox to be specific, she told me that if there's a weapon handed down to you as a gift, I'm able to carry. That's what she told me. I'm not going to sit here and lie and say that.
But Mr. Malone, let me pause you, sir. Let's just assume for a moment everything you're telling me is true.
Yes,
okay? Yeah. Why dispose of the firearm? Why hide the firearm in the mall?
Because so
in other words, if you're allowed to have it, which is what you're telling me, then why hide it?
Yeah, that's where I was going to get to. So she told me, and she works for you guys. She works for this place, so y'all can call her. And she told me,
Mr. Malone, you got to get real fast to why would you, if you're allowed to have a gun, why would you get rid of the gun and hide it someplace?
Because she told me that when I got out of juvie, she told me that I had a felony. If I get caught with a gun, I'm doing 10 plus years. So when he grabbed me, all I thought about was my son, 10 plus years. I'm going to be gone for 10 plus years, and I blacked out. I was just trying to get away. I didn't hit nobody. I didn't swing on nobody. I didn't do nothing. All I did was run. And I disposed of the firearm because I thought that I had a felony. I was never told that I don't have a felony. I was never told that. No, by juvenile court, by probation, nobody.
Okay.
What I was told was 10 plus years if I get caught with a gun, any firearm. So that's what I was playing in my head when the police grabbed my arm, you know?
Well, but Mr. Malone, I mean, again, what you're saying is someone tells you can have a firearm, and then you also know that you'll get 10 years if you.
No, look, she was like, we was having a conversation with my PO.
Mr. Malone, I've listened to you, sir.
No,
right? You're telling me two different things. You knew you weren't supposed to have a firearm. You created an incredibly dangerous situation, sir. I have listened to you. I'm going to keep the bond in place. I find it's necessary in order to protect public safety. So thank you, Mr. Malone.
For sure.